Governing Council, Federal University, Lokoja. 3, the Vice Chancellor, Federal University, Lokoja. 4, the Registrar, Federal University. 5th, Professor M.S. Audu, Deputy Vice Chancellor. 6th, Professor Lokoja M. Miller, Secretary, Federal University, Lokoja Senior Staff Disciplinary Committee. 7, Barrister Ogala Omar Choko, Head, Legal Services Unit, Federal University, Lokoja. And 8, Professor Jacqueline A. Badaki, Head of Department, Zoology, Federal University. My Lord, parties are absent.
Parties absent, appearances, please. Yes. What's the initial? I heard Onoja. Onoja for the claimants. You have to increase the volume of your device. I can barely hear you. Any representation? Okay, I can hear you clearly now. Any representation for the defendants?
Yes, my Lord.
Yes.
A.Y.
Sorry?
I'm A.Y. Mohammed.
Okay, thank you.
For the defendants.
Yes, thank you. Yes, claimant counsel.
My Lord, we have a motion to amend our processes.
When was the motion filed?
On the 19th of April, 2024.
Okay. That's 19th of April, 2024.
Yes, my Lord.
$2024, you said. I do not have it. I don't have the process. The last process I have is the hearing notice of the 15th of February, 2024.
My Lord, we have 3 motions pending before your Lordship.
Can you identify the motions?
My Lord?
Can you identify the motions that are pending?
Thank you, my Lord.
Yes.
There is the motion for extension of time.
And the dates that's where they were filed.
Yes, my Lord.
Yes.
Motion for extension of time filed in court, 19th April 2024.
19th April 2024.
Yes, my Lord. The motion is dated 8th day of April 2024.
Learned Counsel, I just told you that the last process I have in this file is the hearing notice of January 2024. Do you have any processes?
Yes.
They are just giving it to me now. Thank you. Okay, I was just being given now, so you can see them. Okay, so we have a memorandum of appearance filed on the 19th of April. Then there's a motion of 19th of April for leave order of courts to amend claimant's complaints. Then there's a motion, also 19th of April, extension of time within which the first, second, and fourth defendants. And there's another one, applicants may challenge the competence. Okay, so which one are we taking first?
I submit, sir, my Lord, that the one wherein we seek to enter appearance out of time will take precedence.
Okay, thank you. That is for the defendants.
That's correct, Lord.
Yes, claimant counsel, you're not opposing the application. Claimant counsel, you're not opposing the application.
I'm not opposed to the application, my lord, sir.
Thank you. Defense, you move in terms.
Sorry, my lord, my phone was temporarily off.
I said you
May
move in terms. You move in terms.
I apply to move in terms of the motion papers. Thank you, my lord.
Court application granted. Time is hereby enlarged within which the first, second, and fourth defendants may file the memorandum of conditional appearance, statement of defense. The already filed and served processes are deemed as properly filed and served.
We are most grateful, my lord. My lord, we also have another application wherein we seek to set aside vicarious service on the fourth, and I'm sorry, my lord, third, fifth to eighth defendants. They were served vicariously. There was no personal service. And then we have another application challenging the competence of the suit itself.
So the one that you said something to do with vicarious service, another of extension of time for the first, second, and third. We've taken that one. That's what we just took. Then there's another one, another of extension within may challenge the competence of the originating process. That's what you're talking about.
Yes, my lord.
Okay.
My lord, I'm sorry, I'm not aware that we took the two motions at the same time.
No, I'm just saying, no, I said we just took the one for extension of time.
Yes.
So the next one we're taking now is to challenge the competence of originating process. I don't think if it is a preliminary objection, you don't need extension of time, especially when it has to do with jurisdiction.
No. My lord, it is because of a provision of the rules, which I cannot presently refer to, that gives time limit for challenging the competence. We saw it and we thought it was necessary to bring this application for extension. And I think that should be
Order 5?
Yes, I think so. We mentioned it at the title.
Did you mention the order? If it is order 5, it doesn't give leave for extension of time. It is that I don't think you have leave for extension of time. It has to be brought timeously if it is an issue of irregularity of service. Yes, and so I do not think granting you extension of time will cure the irregularity that you want to cure too.
My lord, we are not seeking to cure any irregularity. We are trying. We are seeking to challenge the competence of the suit itself.
Yes, if you want to challenge the competence, you don't need an extension of time to challenge competence. When the law says that if it is issue of jurisdiction, it can even be challenged at the Supreme Court. So I don't know. Yes. So do I take this that you are with? Yes.
Part of our prayers. Part of our prayers are matters of irregularity. Part of the prayers in that motion. There are matters
and that's what I'm saying. That's order 5 that you want to rely on doesn't give you time to extend. If you don't bring it timelessly, you don't bring it. EU comes with equity must come timelessly. So bringing a motion for extension of time is not applicable in this case. If it is jurisdictions can be challenged at any time. So what are you saying about this motion? Are you withdrawing saying because it is incompetent?
I'm trying to fish out the relevant provision which motivated us to include the first prayers.
Okay. So
I'm sorry, ma'am.
Are you not still the one that you are for the defendant?
Correctly, my lord.
And so the claimant still has his own motion for leave to amend the claimant's complaints. Are you opposing that?
Yes. On point of law, my lord.
You've not filed any counter affidavit?
Ordinarily, we are not opposing it on point of facts. My lord, ordinarily, we ought not to oppose an application seeking to amend. But my lord, if my lord take a look at the formation of the prayers and even the proposed amendments, my lord, they are outrightly unprocedurable. They are incomprehensible. They do not tally with the exhibited proposed amendments, which is visible. We don't need any counter affidavit for that, my lord, sir, with due respect. They have excuse me.
Okay, so have you found the relevant rules about this one? Otherwise, I'm going to strike it out immediately as being incompetent because you do not need that.
Ask God, please, my lord.
Well, maybe for the meantime, sir, we withdraw the first prayer.
Which prayer is an extension of time within which to challenge the competence of originating process?
Yes, the first prayer.
So I will record you that we still have a pending application.
Yes, we restrict ourselves to prayers.
We have another application also filed on 19/04/2024.
Yes, my lord.
We wish to withdraw
the first prayer.
The first prayer of the said application. Yes, claimant counsel.
Lord, from onset, we are not allowed to participate in the application. We are not even aware of paying.
What do you mean?
My Lord actually said that the application is incompetent in whole, in parts.
When?
Did
you file a counter affidavit about the incompetency?
Just be granted. So, a claimant needs time to respond to whatever thing he has before court. The court is telling him that I just granted your application, and I just granted that service has been effected today. So the claimant is entitled to respond. So is it what they granted today that the claimant will be responding today? That is not correct.
Mr. Onoja, you are missing the point here. The one that I granted is extension of time within which they will bring their statement of defense. Now they have what they call titled motion, which is ordinarily notice of preliminary objection. They do not need time within which to bring a notice of preliminary objection on issue of jurisdiction.
And my Lord has said, he demands that you do timeously, and if you don't do timeously under order 5, before you take steps, it will be struck up. And he has taken several steps. He has taken several steps. And
that means you have to file a counter affidavit in that regard,
yes, to
because I
challenge
cannot take it.
that's what we are saying. That's what we are saying. To challenge the incompetent motion.
My Lord, we did not take any steps before we file our
learned counsel. I'm sure you know that you are not the only one, and this is the first case that I'm handling. Please be conscious of the fact that others are still waiting to be attended to. So what are we going to do on this application, please?
My Lord, I wish to reply to what he said. Yes. Hold on now. I'm talking to my Lord. I'm addressing the court. My Lord, what I'm saying is that the motion that we just moved and granted is for extension of time within which to enter appearance. It has nothing to do with an application challenging the competence of the suit, which were served on them more than 5 months ago. For him now to say he needs time to file a counter.
I will record the claimant's counsel as we have not filed a counter affidavit with regard to the motion.
I don't like that.
For striking.
My Lord, I take exemption to my learned friend referring to that motion as incompetent. The court has not ruled on it, and he's saying it is incompetent, quoting the court. I take exception to that, my Lord. No, you can't. The court has not ruled on something, and you are labeling it incompetent. What makes it incompetent?
I said I'm listening to the argument. What are you taking exceptions to? I said this is number one. Okay, that we don't have all the time because of the peculiarity of the sitting. The next episode, be conscious that we have all waiting. So what are we doing on that?
He was quoting the court as having ruled my motion incompetent.
I did not say that. I did not say that.
All right.
My Lord, I have the right to describe any process before your Lordship, and it is the right of your Lordship to say that my description is wrong.
We have not filed the counter affidavit with regard to the motion for striking out. And
my right to describe the process the way I want cannot be taken away by any.
Can I stand this case down if you want to argue? Can case 2 down, please? Can you call the next case, please?
When you
are ready, when I call all the other cases, you come back.
I'm fully ready, my Lord. I apologize on his behalf.
Registrar, please call the next case.
I apologize on his behalf, my Lord.
Yes, number 2, when you're ready, when I go through all the matters, then you come back, please. Yes, number 2, please.
NSC 28M 2024 between Ismail and Juma Zuriatu, Adeniyi Kakende, Ed Yusuf, and Matthew Jiga Moses 6. Sister Okosun. 7. Ojogbe. And police government, Kogi State Police. 3. Attorney General and Commissioner for Justice, Kogi State. My Lord, 5th and 6th applicants.
Which of the parties is present?
5th and 6th applicants, my Lord.
5th and 6th.
5th and 6th. Others.
Which parties are present?
Number 5.
My Lord.
Number
5th
5
and 6th.
applicants.
Yes, thank you. Others are absent. Appearances, please.
May please, my Lord.
Yes.
My name is Austin Oboni.
Yes.
Humbly,
Yeah. Yes. Who is the defendant in this matter?
Yes, sir.
I didn't hear who you are representing. Is it the claimant or the defendant, Mr. Oboni? You are muted.
My Lord, we are in that matter.
My Lord, the applicant.
Yes, who is the you said you are the claimant applicant or claimant defendant or whatever.
Applicant.
Okay, judgment creditor applicant. Okay, who said he's interested in the matter?
My Lord, my name is Ekpa.
Mr. Ekpa?
Yes, my Lord.
Well, who are you representing?
I'm representing the judgment debtor.
Okay. What is the application?
Appears with me.
Yes, what is the application?
It's an sir.
I'm sorry, my Lord. Please hold on.
It's an sir.
My Lord, I want to draw
Yes.
Lordship's attention to the concern on this matter.
Yes.
My Lord, sir.
And so how did the defendant comment? How do you comment judgment debtor when it's...
I don't...
My Lord, may I speak?
Judgment debtors, you are not supposed to be in this matter.
My Lord, this matter, there is a ruling of this honorable court. Now JCA staying further proceedings in this matter because appeal has been entered. So we are surprised.
Yeah, but at this stage, you are not supposed to appear. And that is the reason, after I grant the order, we will say it should be served. It is at that point that we want to make it absolute that you comment. Is that not the procedure?
As the court,
we are in court. We are in court. And if the court is not properly informed, it's our duty to pay the court's attention to the true facts.
Okay.
We don't have to go.
I will record you. Excuse me. It is a motion ex parte.
Yes, my Lord.
For garnishing proceedings.
Yes, ma'am.
Judgment debtor. This application is what?
This application is intended to mislead the court, my Lord.
On how is it intended to be mislead?
Because there is an order of this honorable court of 18th October 2023, staying further proceedings in view of the pending appeal that has been entered.
Because there is an order
of this honorable court.
Order of courts staying
further proceedings.
When was the order granted?
18th October 2023.
Staying further proceedings of this matter until the appeal is determined.
Yes, my lord.
And my lord, we wish that that's not two positions.
I will adjourn for the judgment debtor to file an application in this regard because I can only act on facts that are before the court.
Oh, please.
In view of the submission, this matter shall be further adjourned. So let me give you a date. So by then you file in all the processes so that we can know what we're doing here.
As copied.
Lord, if
the 13th of February, please.
Take over the
proceeding. Court's case is adjourned to 13th of February 2025 for hearing.
As copied.
Yes.
Number NICN LKJ 29 2024 between Olorujuwon Ate and 1 Kogi State Government, 2 Attorney General and Commissioner for Justice Kogi State, 3 Kogi State Lokoja. My lord,
that is absence, appearances.
May it please me, Lord.
Yes.
I am A. Onoja. My appearance is for the claimant.
Yes. Any representation for defense? Yes, Mr. Onoja.
My lord, the processes as filed, the defendants have been duly served.
Yes.
And they have not entered the appearance. I haven't mentioned the matter. May we apply that the matter be set down for hearing?
You have to file an application setting down the matter for hearing so that we'll be sure that the defendants do not want to come. That is by the rules of the court.
Most grateful, my lord, sir. Most grateful, my lord, sir.
Thirteenth of February for further mention.
As God pleases.
Court case is adjourned to 13th of February 2025 for further mention. Hearing notice shall be issued and served on the defendants.
Case number 4, NICN LKJ 04-2023 between Suleiman Dadao and 1 Kogi State Polytechnic. My lord, claimant is in court. Defendant absent.
Which case did she call? Which case did you call registry?
Number
0423. Suleiman Dada.
Suleiman Dauda. Okay, yes. You said the claimant is in court.
Claimant is in court, my lord. Yes. Defendant absent.
Claimants present, defendant absent. Appearances.
May it please me, Lord. I am here, Onoja. My appearance is for the judgment creditor respondent.
Yes.
Along with humility, I'm F.O. Epa. G.O. Salifu
Yes.
is appearing with me for the judgment debtors applicants.
Yes. What is the application?
Hello, the application is seeking your lordship's order, setting aside the Form 48 issue and then staying execution of the judgment.
Yes. It was filed on 11th of April.
Yes, my lord.
2023. Yes. Judgment creditor.
Yes, my Lord. We have to regularize that.
You filed a motion to regularize.
No. This is a different. Yes, my Lord. A motion to regularize the 7th of July.
Yes, we have filed a motion for extension of time.
That motion was granted.
Okay,
It was granted on 23rd of July.
okay. The application.
So this has been granted when?
23rd of July, 2023. Sorry, 23rd of November. November 2023.
Okay, yes. Yes, since it has been granted, so what are we doing? I still have cases that I stood down in Abuja, so that's why you can't even afford to just waste any time. Yes, what do we have?
Well, the application is brought pursuant to Order 3 Rule 71 of your lordship's rule.
Yes.
Seeking an order setting aside Form 48 issued against the applicant. Prayer 2, seeking your lordship's order staying execution of the judgment pending appeal. And for such further orders, your lordship may deem fit to make in the circumstance.
Yes.
Now, the grounds upon which the application is predicated is contained on page 1 of the motion paper. Basically, that the applicants have filed an application for leave of the Court of Appeal to appeal the judgment.
And do you have the exhibits? That's exhibited that leave has been
yes,
applied for.
It's attached to the further affidavit in support.
Yes, okay. So you continue.
Scott, please. Well, the application is supported by an affidavit of 5 paragraphs, deposed to by Aro Oluwakemi.
Yes.
There is also a further affidavit in support of the application.
When was that filed?
The further affidavit is filed on the 18th of April, 2023.
Okay. Yes.
Well, the further affidavit is of 6 paragraphs.
Yes.
And attached to exhibit MYA1 is the application pending before the Court of Appeal, attached to which is a full notice of appeal as well, my lord.
Yes.
Well, we rely on the paragraph of the 2 affidavits, and we have a written address in support of the application. We adopt same arguments in urging your lordship to grant our application, as the essence is to give the applicants the opportunity to ventilate their grievance at the Court of Appeal.
Yes, thank you. Mr. Onoja.
Thank you, my lord, sir. The judgment creditor.
Judgments. Yes.
The judgment creditor is 17 affidavit.
Yes.
Judgment creditor.
Yes.
The fairness of proceed to rely on the counter by urging your lord supported us.
Thank you.
I'm not the written address.
Okay.
And
I thought. Okay. Yes. We adopt the written address.
Yes, in conformity with the written address, and next to the counter, and with the list of to adopt and urging your lordship to give a barrier to the purported application. While we equally argue that Order 3 Rule 7, which they purport to rely on, has nothing to do with this nature of application. Rather, it is Order 64 of the rules of this honorable court.
Yes,
And
thank you.
below, sir, please, just a minute, let me cap it up. By Order 64, Rule 8 to 13, it expressly maintain what an applicant in his nature are supposed to do. That they did not do. And this court has ruled time without number that unless that provision of the Order 64, Rule 8 to 13 is complied with, nobody can be granted an application for stay of execution. And one of such is a monetary judgment. The Order 64, Rule 8, 9, 10 provide that deposit the money with the register of the court, come, apply. And secondly, have you gotten the leave you are seeking for? Is there any appeal before court? Have you transmitted record? Unless you comply with such requirement, your application is stifled and it will be granted. And it's on that note that I urge your lordship not to consider this application in the interest of justice. May this court.
Thank you. Case is adjourned to the 6th of March, 2025 for ruling.
As officer, March
6th of March.
Thank you,
6th
Lord.
March.
Yes. Lord.
Yes. Claimants present, defendants absent. Yes. Appearances.
May I please, my lord.
Yes.
My name is Austin Oboni.
Yes, this is this case is Abigail Elejo, thank God. Is that the case? Yes. Austin Oboni for who?
For the claimant.
That is a mistake, my lord.
Yes, defendant.
My lord, in this case, my lord.
Yes.
In this case, my lord.
Yes, thank you.
My lord, sir.
Can I announce a
change of counsel?
My lord, we are in this matter. Hello, my
Who
name
is
is
in the matter again? Who is in the matter?
F.O.
F.O. is in the matter as who?
For the defendants, my lord.
What about A.O. Onoja?
The claimant.
What about A.O. Obone?
Austin, the claimant, sir.
Austin Obone is for the claimant. A.O. Onoja is for who?
The claimant.
You people are not serious. You have a notice of change of counsel. So Obone is the present claimant's counsel. So who is the defendant's counsel here?
So the matter has not been resolved. It's a pending issue.
Do we have
What, sir? The claimant decided to change her counsel.
So I have a notice of change of counsel. The court has a notice of change of counsel.
Yes, my lord. And there's an issue with that. Well, it has been tabled before the court, which the court has done to resolve the issue that is pending. The notice is a purported notice. It does not comply with Order 54. That's what we are saying. And
you cannot be saying so, Mr. Onoja. You cannot be saying things without filing applications, please, because the peculiarity of this proceedings. I'm dealing with the processes that I have before me. If I do not have any processes, I will not take it. Please.
Yes.
So the present
the process before you was before your predecessor, and the issue was raised on it. And the issue that was raised was expressly stated to the court requested that certain action be taken. It was not me. It was not me that the court would take the action. The court cannot
I'm not aware of that. There's no record on these things that you are stating, and that's why I said it is important that you file processes to enable us know what is going on. So
may I apply that the matter so that you can file processes?
Mr. Onoja,
yes, Lord.
I apply
that the matter be adjourned to respond to the purported change of counsel, the application before a notice of a purported notice of change of counsel, which has been before the court before.
Lord, sir.
Yes.
The claimant is in court. The claimant
I'm not yet. Excuse me, Mr. Oboni. I'm not here to be asking claimants who is your counsel. Can you please file the proper applications, please.
As the court pleases.
The 19th of March, is it convenient? I hope they hear me. Did you hear me, 19th of March?
Yes, my lord.
Court case is adjourned to the 19th of March, 2025 for hearing.
As court please. Yes, number 6. NICN LKJ 22-2023 between Paul E. Onoja and 1. Kogi State Government, 2. Attorney General and Commissioner for Justice, 3. Kogi State Civil Service Commission, 4. Head of Service, Kogi State, 5th. Kogi State Pension Board. My lord, claimant is present, defendant absent.
Yes, appearances.
Onoja, my appearance for the claimant.
Yes.
My lord, I am F.O. Ekpa with G.O. Salifu for the defendant.
Yes.
My lord, the matter is for you, and if it's convenient for us, we are ready to proceed. Keep it aside. Let me know anything.
Defense, are you ready?
No, we are ready.
I have a judgment that I'm reading at 1 o'clock. If you can still wait online, fine. If you cannot, we adjourn.
Ask her, oh, wait on that.
Okay. Case stood down.
Sorry, my lord. My lord.
Yes.
My lord, I have a matter at the Federal High Court in Abuja tomorrow. I need to travel today.
Yes.
So, my lord, in the circumstance, my lord, I think an adjournment is preferable.
The only reason we're taking cases in the afternoon is just so that I will accommodate Lokoja cases. Otherwise, all these cases will not have even been mentioned this year. So as from next year, by God's grace, when they're sitting, it is 10 o'clock.
As court pleases.
Yeah, it's just so that we will mention all these cases, and it won't be that cases have been left since April, May, and nothing has been done. And so that's why we're hearing it in the afternoons. But from next year, by God's grace, I will have organized the diary so much so that I will separate Lokoja cases from Abuja cases. So whenever Lokoja cases is coming up, it is from 10 o'clock in the morning. Thank you.
Because I attend with my colleague flight, but the claimant have the distance of over 400 kilometers to come for this matter, and he's still going back in that same light. I'm begging my colleague so that we'll take this matter on record. Sir? No, I'm not saying that I should travel. And let this guy take the case now, please.
Mr. Ekman, do you agree to take the matter on record? Trial
No, my
on
lord.
record?
No, my lord.
He said he doesn't. You have to both agree before the court can do that. Unfortunately, the rule does not allow the courts to impose on parties. It has to be agreement between parties.
My lord, what I'm telling my colleague is simply that he knows where the claimant came from. It's a distance of about
Mr. Ekpa,
400
I have
kilometers.
a judgment to deliver at 1 o'clock. Are you ready to adjourn?
My lord, in the circumstance, I prefer an adjournment, and that's the point, because I explained to him I'll be traveling.
Court case is adjourned to 19th of March 2025 for hearing.
As court pleases. Most grateful, my lord.
Yes.
Case number 7, NICN LKJ 09-2022 between Arua Adejo and 156 others, and Federal Polytechnic Ida and 2 others. My
How
lord,
many do we have?
claimant number 59 and 105 is in court. Others absent.
Claimants 59 and 157 and 112.
105.
Yes, appearances.
Please, my lord.
Yes.
My name is Austin Obuni. I appear for the claimant.
Yes.
My lord, the defendant counsel is not in court today again, sir. In spite of the service of hearing notice, sir.
Yes.
We have an application for the court. It's
My lord,
what? Yes.
the defense sent in late morning that they have not of their counsel in the matter. So they have an adjournment.
That what?
They have lost of their counsel handling the matter.
I didn't hear the excuse.
The Polytechnic sent in a letter, sir,
That what?
that they have lost the confidence of the council handling the matter for them.
Okay,
And
they lost confidence in the council.
It's no longer
Yes.
the council handling the case for them, and they refuse to bring in somebody else. And we have been serving them the Polytechnic processes direct, and now they are saying they lost contact of that council. And that's what this is the third time my lord is taking us in this matter just because of this application. Today is the third time we are coming before my lord, sir.
What is the application that is pending?
Yes, this is an application for amendment, sir. For leave to amend your process, sir.
Don't you think? Okay, let's take the amendments.
As the court pleases. Lord, the application is.
When was it filed?
On the 24th, 23rd April 2024, sir. 23rd. See, meet yourself.
23rd April 2024. I pray I have the application. Did I see the application before? Yeah,
yes,
I've seen it. Okay.
Several.
Okay, we have a pending. This is about the third time.
Yes, my lord. Mute your phone.
Yes, you can move your application. Yes, claimant counsel.
Lord, the prayer is as contained on the face of the motion, sir. It is supported by a 6-paragraph affidavit. Equally, adopt our written address, sir, and the exhibit, which is the proposed amendment, sir. Lord, you may to grant the application. We are grateful, sir.
Court ordered as prayed. Leave is hereby granted to the claimant as follows. 1, to amend the claimant's originating process to wit, A, striking out the names of 2nd, 3rd, 4th, 32nd, 5th, 35th, 51st, 52nd, 68th, 110, 112, 132, 136, 139, 145, 152, and 153 claimants. 2, to join Pension Transitional Arrangement Directorate as the 4th defendant. And 3, adding prayers 8 and 9 to the reliefs. And to amend the claimant's statements of facts and amend the list of witnesses. The amended processes shall be filed and served on the defendants within 7 days.
As the court pleases, my lord, we are grateful, sir.
Yes,
May
so we
we ask-
adjourn.
may we ask for
The 19th of March.
if we can have a date in January, I will appreciate, sir.
Do you mean January 2026? 19th of March 2025 for hearing. Hearing notices shall be issued on the defendants.
My lord, we are grateful as the court pleases.
Yes. Is it the one
My
stood
lord,
down?
I will stand
Yes.
down.
No, I have a judgment. They think I'm joking. They wait online. Those ones have been waiting since. After the judgment, if they are still online, I'll take them. Can you call the case for judgment, please?
As God pleases.
Case number 1. NICN ADJ 320,022. Mr. Kennedy Oji and United Parcel Service Nigeria Limited. And our practice after.
Just a minute. Got to minimize this. Yes, parties absence, appearances, please.
May it please my lord,
Yes,
CJ Nnamdi,
yes.
CJ Nnamdi, most humbly.
Yeah, I heard you.
Yes, my lord.
For the claimant.
Yes, my lord.
Yes.
Most
Yes.
respectfully,
Yes.
my lord, Ikini Magaguna, for the defendant.
Court judgment. Are you here?
Yes, my lord.
Okay, we have somebody appearing with you physically. Yeah, what's the name? For the defendant? Okay. I was wondering. I thought you were just using our facility. With Idris Akinola for the defendants. Yeah. Judgment. In summary, the case of the claimant is that the defendants breached the condition of a service in the dismissal of his appointment, and his right to fair hearing was violated. Thereby, he alleged that the dismissal of his appointment is unlawful, null, and void. The claimant further alleged that he has suffered psychological, emotional, financial losses and injury to his name and reputation by the actions of the defendant. On the basis of these essential facts, the claimant instituted the instant action void complaints and statement of facts filed in this court on the 12th of October 2022, wherein it claims against defendants jointly and severally the relief set out as follows. I have 8 of the reliefs are stated on the face of the judgment. The first defendant in a statement of, I will skip it so that we will save time. The first defendant in a statement of defense deemed filed on the 2nd of March 2022 contends that the claimant is not entitled to the reliefs and further contends that the claimant's action is misconceived, lacking in merit, and urged that his action should be dismissed with substantial costs. The second defendant did not file any process in defense of the case. The claimant's reply to the statement of defense of the first defendant was also deemed filed on the 2nd of March 2023. At the plenary trial, the claimant testified for himself and called no witness. He adopted a statement on oath as his evidence in chief in support of his claims and further tendered a total of 9 documents. The claimant was subjected to cross-examination by the first defendant, learned counsel, after which his case was closed. The first defendant elected to rest his case on that of the claimant, even though a statement of defense and witness deposition on oath of the sole witness was filed. Thereafter, parties filed and exchanged their written final addresses in the manner prescribed by the provisions of Order 45 of the rules of this honorable court. In the final address filed on behalf of the claimant on the 30th of July 2024, Ms. Learned Counsel C.J. Nnamdi, Esquire, identified 3 issues as having a reason for determination in the suit, namely, 1, whether in view of the claimant's case there was compliance with the extant provisions of the defendant's employees handbook in the event leading to the dismissal of the claimant. 2, whether the claimant was granted fair hearing before his eventual purported dismissal by the defendant, and if the answer is in the negative, whether he is entitled to his claims as per the complaint. And 3, whether the claimant is entitled to the relief sought in the complaints. The first defendant in turn filed his final address deemed properly filed on the 15th of October 2024, wherein Ekene O. Maduguna, Esquire of Learned Counsel, distilled 2 issues as having a reason for determination in the suit, namely, 1, whether the claimant has established by credible evidence that his dismissal by the defendant was in breach of the terms of his employment and the principle of audi altera partem, such that the dismissal could be regarded as wrongful. 2, whether the claimant is entitled to relief sought in the statement of facts or any relief whatsoever in the light of the evidence elicited on the cross-examination in support of the defendant's pleadings, which establishes the reason for summary dismissal of the claimant. Upon a proper appreciation of the totality of the pleadings of the respective parties, the evidence adduced at the trial, and the totality of the circumstances of this case, it is my considered view that the focal issue that called for a resolution in the suit without prejudice to the issues raised by the parties could be succinctly framed as follows. Quote, whether or not the claimant established his entitlements to the reliefs claimed in the suit against defendants, end of quote. In proceeding to determine the issue, I must state that I had carefully considered and taken due benefits of the totality of arguments canvassed by the respective learned counsel in the written final submissions, to which I shall endeavor to make specific reference as I consider needful in the course of this judgment. The tried position of law is that in an action for declaratory relief such as the present case, the claimant is duty-bound to prove his claim on the strength of his own case. This is essentially so because declaratory reliefs are not granted on a platter of gold. They are only granted as products of credible and cogent evidence preferred at the instance of the claimant. See the cases of Colonel Nicholas Anyaru retired versus Mandilas Limited and Nweke versus Okori, citation supplied. By my understanding of the totality of the case of the claimant, it seems to me that the basic, essential, and relevant facts upon which the claimant has predicated his claims could be enumerated as follows. 1, he was initially appointed as a casual staff by the first defendant, and on the 12th of August 2014, he was offered a full-time employment as a dispatch rider. 2, based on the instruction of the company as a dispatch rider, the products or packages of the company are either delivered as cash on delivery, that is COD, or free of charge FOC. 3, on the 2nd of November 2020, he delivered 4 packages with free of charge inscriptions from the headquarters in Lagos to Director of Finance, Federal Ministry of Foreign Affairs, Abuja. For 2 weeks thereafter, a reconciliation notice was sent from Lagos office on the allegation that he collected money for the said packages that was delivered as the packages were not FOC, and as a result of the investigation, he was invited by the manager in Abuja. 5, he offered explanation that no remittance was made for the packages because they were FOC, and pleaded with the manager for time for him to request the director to whom the packages were delivered to pay for the delivery. 6, eventually, the said director paid for the packages. On the 25th of November 2020, he remitted the money to the first defendant and receipts were obtained for the payment. 7, subsequently, the manager informed the internal auditors of the first defendants about the incidents, and based on the reports, an allegation of late remittance was made against him. The grievance of the claimant is further that the first defendant gave him a letter of dismissal without any query or warning issued to him to explain before any panel, to explain what transpired, and that a suspension letter was neither issued to him or was he given the opportunity to state his case, to state his defense. The claimant contends further that he was entitled to be heard, the allegation being criminal in nature, and also alleged that the first defendant failed to comply with the prescribed grievance procedure as laid down in the employee's handbook before he was purportedly dismissed. The claimant further testified that after his dismissal of his appointment, letters were written to the defendant for him to be given opportunity to defend himself, but to no avail. The claimant further alleged that he has suffered great loss, pain, psychological trauma, distress, and shame as a result of a summary dismissal that was in bad faith, without justifiable reason, and malicious. To further support his case, the claimant tendered in evidence the following documents: 1, letter of offer of probationary appointment dated the 12th of August 2014 as Exhibit C1. 2, employees handbook of the defendant as Exhibit C2. 3, query for non-remittance of Sumex fund dated the 21st of October 2020 as Exhibit C3. 4, receipts issued by the defendants to the Director, Finance and Accounts dated the 25th of November 2020 as Exhibit C4. 5, letter of summary dismissal dated the 19th of February 2021 as Exhibit C5. 6, letters written by the claimant to the first defendant dated the 19th of March 2021 and the 9th of April 2021 as Exhibit C6 and C6A. 7, statement of accounts of the claimants with Guarantee Trust Bank PLC as Exhibit C7. Exhibit C3A, the reply of the query was tendered through the claimant under cross-examination by learned counsel for the first defendant. As I had noted earlier, the first defendant had filed a statement of defense wherein it denied the entirety of the claimant's claims, but elected to rest its case on that of the claimant and did not call any witness or tendered any documents in defense. As correctly submitted by learned counsel for the claimant, it sees the law that where a defendant does not adduce evidence, the evidence before the court goes one way, leaving the court with no other evidence or set of facts with which to do the measuring of the scale. This is because in a situation while a where a defendant leads no evidence in proof of the facts pleaded by him, such pleading is deemed abandoned, and the defendant will be left with nothing with which to present against the claimant. Furthermore, it is settled that where a defendant abandons its pleadings and rests his case on the claimant's evidence, he is deemed in law to have completely accepted the pleadings and evidence or the case presented by the claimant. In a situation as the present case, it may mean, one, the defendant is stating that the claimant has not made out any case for the defendant to controvert or respond to, or two, he admits the facts of the case as presented by the claimant, or C, or three, he has a complete legal defense in law in answer to the claimant's case. So the case of Deck Oil and Gas Limited versus Shell Nigeria Gas Limited and another 2021 Law Pavilion Electronic Law Reports as 53462. Without a doubt, burden of proof is on the party who alleges the affirmative, and it lies on a party who will fail in the case where no evidence is given. Generally, the burden of proof rests on the claimant. In labor law, it is equally settled that the onus is squarely on a claimant in an action for unlawful dismissal or termination of appointment to prove the existence of the contract of employment, the terms and or conditions thereof, and how those terms and or conditions were breached by the employer. Flowing from the above principles, the claimant herein must not only plead and prove the terms and conditions of his appointment, he must also prove that there was a departure from the prescribed procedure, or that in applying the procedure there was violation of the rule of natural justice so as to render the formal compliance a travesty. See the cases of Mwachukwu versus Ngwose, Wayek and others versus Inkang, Nigerian Gas Company Limited versus Tutushola, Oloruntobi Oju versus Abdurrahim, Imaswen versus University of Benin. See also Audu versus Petroleum Equalization Fund Management Board and another, cited by Learned Counsel for the first defendant. Now, parties are ad idem that the employment between the claimant and the first defendant was governed by Exhibit C1, that is the letter of offer of employment, and Exhibit C2, that is the first defendant's employee handbook. With reference to Exhibit C2, the argument of Learned Counsel for the claimant is that Part 5, Article 39A, Paragraph A to Paragraph E of the said exhibit provides for grievance procedure. That involves service of written query or warning to a defaulting employee, and he further argued that a single query issued in October 2020 was manifestly offensive to the first defendant's rule as embodied in the handbook to warrant the summary dismissal of the claimant. Learned Counsel submitted that a right to question a wrong done can be waived, abandoned, or relinquished either expressly or by conduct, and argued further that the defendant had waived the right to dismiss the claimant for failure to exhaust the procedures provided by the handbook. The argument of Learned Counsel, claimant's counsel, is further that the way and the manner in which the defendants treated the claimant amounted to flagrant breach of his right to fair hearing as enshrined in Section 36 of the Constitution of Federal Republic of Nigeria as amended, and submitted that the constitutional provision of fair hearing and common law principle of order authorized pattern can only be satisfied when a disciplinary body is constituted and the person is given an opportunity to be heard. On his part, Learned Counsel for the first defendant placed reliance on the case of CCECC Nigeria Limited versus Igala and others, 2020, Law Pavilion Electronic Law Report at 51183, and argued that in the instant case, the claimants failed to prove that there was a departure from the prescribed procedure, or that in applying the rule, there was violation of rules of natural justice to render the formal compliance travesty. Learned Counsel argued further that the first defendant adhered to the prescribed disciplinary procedure and application, and also complied with the rules of natural justice. Learned Counsel further submitted that the allegation of wrongful dismissal is bereft of evidence. At this juncture, I should remark that it seems the argument of Learned Counsel for the claimant in paragraph 3.2 of his written address is hinged on the assumption, erroneous as it may be, that the appointment of the claimants was terminated. Undoubtedly, a contract of employment may be brought to an end by termination or summary dismissal. In law, the terms dismissal and termination of contracts may appear intangible, but they have distinct meanings and implications depending on the nature of employment relationship. Most employments provide the terms which govern either of those consequences in a staff manual or handbook. The primary distinction between dismissal and termination of a contract lies in the nature of the act and the circumstances surrounding it. Termination of contracts can arise from the natural expiration of an agreement or by mutual consent of both parties, or where either party to the employment contract finds no further need to continue the employment relationship. The most prevalent method of termination of a contract of employment is by delivery of a written notice from one party to the other. Either party could equally elect to pay compensation in lieu of notice. Termination of contract, especially when done without fault or through mutual agreement, generally preserves the employee's right to claim benefits like severance allowance or the full fulfillment of the contract terms. Summary dismissal, on the other hand, is the right of an employee to terminate the contracts of service of an employee with neither notice or payment in lieu of notice, and it involves legal grounds related to the employee's performance or conduct such that it undermines the relationship of confidence which exists between the parties. In other words, what amounts to misconduct is as defined by the employer. Additionally, dismissal for just cause may have adverse legal consequences for the employee, such as the loss of separation of benefits. The term gross misconduct was defined by Apex Court in UBA versus Ogbo, 1995, 2 Nigeria Weekly Law Report, Part 380, page 647 at 653, as I quote, conduct of grave and weighty characters as to undermine the confidence which should exist between the employee and his employer, or working against the deep interests of the employer, end of quote. Now, there is no contention by parties that the disciplinary procedure of an employee is prescribed in Article 39 of Exhibit C2. The relevant provision on dismissal states as follows, I quote, the law provides that employees may be summarily dismissed for certain offenses covered by broad headings of incompetence, disobedience, negligence, or misconduct. Despite laid down disciplinary procedure an employee will be liable for summary dismissal in the following events. The events include misrepresentation of facts and information required by and or given to the company, and 20 other events were listed. It was further stated that the examples of the events are not exhaustive, and employees guilty of serious misconduct may be summarily dismissed. The evidence on record is that a query, Exhibit C3, was issued to the claimant on the 21st of October 2020 to give reason why disciplinary action should not be taken against him for his failure to remit monies received from Slimex delivery that had been delivered since the 13th of October 2020. In his reply to the query in Exhibit C3A on the 28th of October 2020, the claimant tendered his apology for the delay in remittance and stated that the delay was due to unforeseen circumstances. While answering questions under cross-examination by the learned counsel for the first defendant, the claimant further testified. The claimant's further testimony was in line with his reply in Exhibit C3A that he apologized for the delay in remittance of the packages delivered. Still under cross-examination, the claimant further testified that the payment for the delivery of the packages was not made to the defendant on the same day that he received the money, that he did not seek for the approval of the manager before the money was utilized for a pressing personal need, and also testified that the defendant did not issue a written waiver to him for the delay in remittance of the delivery payment. It is settled law, and as correctly submitted by learned counsel for the first defendant, that evidence elicited from the party or his witnesses under cross-examination, which goes to support the case of the party cross-examining, constitutes evidence in support of the case of or defense of that party. If at the end of the day, the party cross-examining decides not to call any witness, he can rely on the evidence elicited from cross-examination in establishing his case or defense. In such a case, it cannot be said that the party called no witness in support of his case or defense or evidence, as the evidence elicited from his opponents under cross-examination, which is in support of his case or defense, constitutes as evidence in the case. This was the position of the Apex Court in the case of Akomolafe and another versus Guardian Press Limited and others, 2010, 3 Nigeria Weekly Law Report, Part 1181 at page 338. The reason for summary dismissal of the claimant, as stated in Exhibit C5, the letter of summary dismissal, is that he had previously, upon inquiry, admitted to have withheld funds that were mandated to be remitted to the company daily, and that after he had pleaded and assured that such acts of misconduct will not be repeated, a similar incident occurred in November 2020, where he committed the same action. These actions were considered to be serious misconduct and breach of the first defendant. Now, it is a settled position of law with statutory backing and a legion of decided authorities that what is admitted needs no further proof. See Section 123 of the Evidence of Act 2011. No facts needs to be proved in any civil proceeding which the parties to the proceedings or their agents agreed to admit at the trial, or which before the hearing they agreed to admit by any writing under their hands, or which by any rule or pleading in force at the time they are deemed to have been admitted by the pleadings, provided the courts may in its discretion require the facts admitted to be proved otherwise than by such admission. There are too many decided cases on this principle. See the cases of Akilagun versus Oshoboja, Alhaji Ndayako versus Alhaji Dantoro, and 6 others. Citation supplied. In paragraph 23 of a statement of facts, the claimant testified that no written query or warning was issued to him to explain before any panel or authority regarding the incidents of 2nd November 2020. That is, the claimant admitted that another allegation of misconduct was leveled against him, but his contention is that no query was issued and that he was denied fair hearing since no panel was set up to investigate the said alleged misconduct. It is equally an elementary principle of law and indeed well settled that parties are generally bound by the terms or condition of an agreement which they voluntarily entered into. It is also trite that the courts are bound by the terms of agreements which parties before it had freely and validly executed. Thus, if a court is called upon to construe an agreement, the court cannot but limit itself to the express terms of the agreement as indicated and or specified by the parties. This is because where the parties have embodied the terms of their contracts in a written document, extrinsic evidence is not admissible to add, vary, subtract from, or contradict the written terms of the contract or agreement. Therefore, where a court is faced with the task of interpreting a written instruction or agreement from one party to the other, or between two or more parties, as the case may be, it is expected that it will carry out its duty within the walls or confines of the written and express terms of the instruction or agreement. See the cases of Babatunde and another versus Bank of North Limited and others, Chukwu and another versus Chukwu and others, citation supplied. There is no dispute between parties that Exhibit C3 is binding on the parties, and by the position of law, this court is enjoined to interpret same as agreed by the parties. The argument of learned claimants counsel is that the first defendant failed to comply with the procedure as prescribed in Part 5, Article 3, Paragraph A to E of the Employee Handbook in dismissing the claimant's appointment. I had carefully reviewed the disciplinary procedure as stated in Article 39. The procedure for summary dismissal in Article 39, Paragraph E is clearly distinct from the procedure for termination of appointment. By Paragraph 39E, in cases of summary dismissal, the defendant has the liberty to dispense with the provision with the procedure as stated in Articles 39, Paragraph A to E, that is, the procedure for termination of appointment. From the facts and evidence presented, the provision of Article 39, Paragraph A to D are inapplicable in the instant case for dismissal of appointments. And I so hold, having held that the provisions of Article 39A, Paragraph A to E is inapplicable in this case, the claimant has not established a case of wrongful dismissal against the defendant. In other words, the dismissal of his appointment by first defendant was not wrongful, and I so further hold. And since the other reliefs being claimed by the claimant is hinged on this claim of wrongful dismissal, the other reliefs fail, and I so hold. On the basis of foregoing analysis, therefore, I must hereby resolve the sole issue for determination in the suit against the claimant. It is therefore the conclusion of the court that the claimant has failed to lead credible evidence in support of the reliefs claimed against the defendants in this action. Accordingly, it is the judgment of this court that the claimant's claim is unmeritorious. It shall be, and it is hereby accordingly dismissed. Parties shall bear their respective costs.
The court pleases.
As the court pleases.
My Lord, we are grateful.
Thank you.
My Lord, may we express our gratitude to the court for the well-considered judgment. May the court be pleased.
So the copy of the judgments will be ready by next week. You can apply if you so wish.
As the court
Thank you, my Lord.
pleases.
Yes, Lokoja, I'm back with you. Are they ready or have they left?
They're ready, my lord.
They are ready, and they've sorted all the arguments that they are using to waste the time of the courts initially. Yes, can you call the case again? This other one. Yes, call the case.
NICN LKD 35/2023.
35 or 36? Is it 35 or is it 36?
36, my lord.
Okay. Yes. Same appearances. Yes, did you say same appearances? So we have somebody that has left. Yes. So what are we saying?
The motion is tried for hearing. With the leave of court, I'm ready to proceed.
The motion, which of the motion again? The one for order for striking out?
No, for amendment. I was going on with it before.
We have not filed the counter with regards to the motion for striking out. However, we have a pending motion for amendment. Yes.
My lord, with the leave of court, I'm ready to proceed.
Yes, defense counsel, are you opposing this application?
I know, sir, on procedural grounds, as I was trying to explain the initial stage. My lord, I'm unable to comprehend that application. If my lord looks at the first prayer, it's an edition of so many types of amendments jumping together. And that was really my first observation of the council when I put in the thought. That the way and manner the amendments were phrased is incomprehensible.
And so this your objection is not on ground of law, it is on ground of facts.
It's law.
Yes? Is law? What law are you citing then, please?
My lord, what we are saying is that the phraseology of the prayer, where is the law, is confusing. So it does not, I don't want to know exactly what the motion means. And if you my lord look at the executed proposed amended process, it does not tell me with the prayers. My lord is a ground of law, it's not facts.
Okay. So I will have to rule on it. Okay, so you can move your application.
Most grateful, my lord. Give me, sir. Let me move it now. Thank you. My lord, the application is filed on the 19th of April 2024.
Yes.
And we pray your lordship for two reliefs. One is the main relief. The second one is an omnibus prayer.
Yes.
The application is brought under the proper laws and rules of this court.
Yes.
In support of this application, my lord, is an 11 paragraph affidavit deposed to by the claimant applicant himself.
Yes.
The Lord will seek the leave of this honorable court to rely on all the paragraphs of the affidavit with their annexures marked as Exhibit A, which is the proposed copy of the amendment sought.
Yes.
In compliance with the rules of this honorable court, the application is accompanied with the written address of counsel.
Yes.
With the leave of court, we seek to adopt same as our argument by urging your lordship to grant this application. And the essence of the application is to remove personal names attached to corporate offices sued in the complaint, and also to remove all statements of facts relating to those personal persons in those corporate offices. The application is not incomprehensible, it is legible, and
yes,
the intention of the applicant were duly underlined in the proposed amended document. So for that reason, we urge your lordship to grant this application. May you please cut.
Yes, defense.
However,
yes,
if we see your lordship in justice, to expose to this cause. My lord, the original originating process before the lordship.
yes. The what? What did you say is titled what?
The originating process.
I can't hear you. Your voice is echoing, so it's difficult to hear you. Yes?
The originating process is. Is it on? Sorry, my lord, sir. The technical hitch. My lord, I'm saying that the originating process in this matter, which is in the court record, is titled writ of summons. There is no application before this court to change that appellation. But they have annexed Exhibit A, in which that appellation was changed to propose amended complaints. That is why I'm saying that the prayer does not tally with the exhibited documents, Exhibit A. So they have affected this amendment without leave of court, because there is no prayer in the motion paper that says writ of summons to be changed to propose amended complaint.
Writ of summons should be changed to what?
Proposed amended complaint.
That's the Exhibit A.
Exhibit A.
Yes. Then the one that the original one, they still stated that it's proposed amended list or something, or what?
Yes, my lord. So the appellations describing the processes, there is no prayer supporting the changes made in Exhibit A.
There's no prayer. There's no prayer. What did you say?
There is no prayer supporting the changes made in Exhibit A. For instance, writ of summons in the original process was changed to propose amended complaints. There is no prayer to support that in the motion papers.
Okay.
That is why we said the motion paper, as it is couched, does not support the content of Exhibit A. Otherwise, if somebody wants to amend, there is no point objecting. But what we are seeing here, my lord, what we see in the motion paper is not what we see in the exhibited proposed amendments. And I was magnanimous enough to point it out to my learned friend upon coming to court.
Yes.
So that is the reason why I said, my lord, that this application in its present form is not grantable. God cannot grant what was not applied for. And even by tampering with the originating process, it's another problem, because there's no power or rights in a claimant to change the content of an originating process without leave of court, which has not been asked for. in the nation paper. My Lord, these are just the elaborations I can give, sir. Then
Thank you.
Thank you, my Lord, sir.
I listen to my is responding on point. Up to today, I don't know any deed of law that gave the power to say what all he has said appoint are not on law. Give facts. The only talk about, and he has not referred to any person. So I urge your lordship to do what he has said. May it please continue.
Okay. Thank you.
Thank you, my Lord, sir.
The 6th of March for ruling.
Let's go. This much. Clock. Thank you, my Lord.
That's the end of the cases?
Yes, my Lord.